Todd Halleck here today, talking to you about estate administration, and in particular, 5 common mistakes that trustees and executors make when they're administering an estate or a trust. The first duty of a trustee is to inventory and appraise the assets of the estate, and that's where I see mistake number 1 happen quite often, is either failing to do so altogether or shortchanging the process and taking maybe easier ways to try to get at what the value of assets are. I really discourage that, and it can be a big mistake. Understanding the value of those assets is going to tell us what each beneficiary is entitled to receive. It's going to tell us whether or not estate taxes are potentially owed, and it's going to tell us under current law what the new tax basis is for that property when it gets sold, which will determine whether or if income taxes are going to be owed on the sale of that property. So really important. You can leave a lot of money on the table by failing to properly value those assets or valuing them too low. So I really encourage my trustees and my executors to not skimp in that area, but get a valuation, get an appraisal, so that we can know what the value of those assets are with certainty as we move forward in administering the estate. The second common mistake that I see people make is failing to follow the terms of the will or the trust. And this happens for a variety of reasons. Maybe it's a little complex, maybe it's easier to do it a different way, maybe they think they're smarter than mom and dad who set up the trust, or smarter than the attorney who drew up the trust. Those wills, those trusts are legally binding documents, and when you accept the duty to administer that will or that trust, you are obligating yourself to follow the terms of it, and failing to do so will put you in legal jeopardy. It will put you at risk of now having your personal assets at risk for the mistakes that you've made in administering the estate. Even if it doesn't raise to that level, it will almost certainly lead to discord among the beneficiaries if you're not following the terms of that will or trust. So follow the terms of the will or the trust. If you think something is unclear, or if you think something is improper, then there's a method for dealing with that, and that's usually by going through the court and getting approval to deviate from the terms of the trust, or by getting the consent of all of the beneficiaries to deviating from the terms of the trust. But unilaterally making the decision to deviate from those terms, big mistake. Mistake number 2. Mistake number 3 is distributing assets too early. It's not uncommon for an executor of an estate or a trustee of a trust to hear as soon as before the funeral from beneficiaries wondering when they're going to get their inheritance. They're in a bind. They could really use the money. They how long is this going to take? They've got this, that, and the other thing they want to get done. Big mistake to release monies too early, especially if it ends up being other beneficiaries' monies that get released too early. You've got to make sure that you've got sufficient to pay the ongoing expenses of the estate, as well as the debts and liabilities of the deceased person that existed prior to their death. And you've got to make sure that everybody is treated according to the terms of the trust. So really discourage early distributions. If somebody's in a spot right now and needs the money, I guarantee you they're not going to be able to pay you back if they need to when that time comes. So mistake number 3 is distributing too early. Mistake number 4, failing to file for portability. This is done by filing an estate tax return on the death of the first spouse. What that does is it moves their estate tax exemption, or the unused portion of their estate tax exemption, to the surviving spouse. Failing to do this in a timely fashion can result in that exemption just disappearing. Right now, that exemption is $11.7 million per person, $23.4 million for a couple. That seems quite high, and doesn't. And most estates are not going to be that large to have a problem. But if we end up with a situation like we're facing, where there's pending legislation to reduce that estate tax exemption, maybe even as low as back down to $3.5 million per person, you might wish you had that extra exemption. So again, not an area to skimp on. If you're anywhere in the range where that could be an issue, make sure you file that 706 estate tax return and get that unused exemption ported over to the surviving spouse It will never hurt you to have done that. Finally, mistake number 5, failing to get a release from the beneficiaries upon final distribution. When you're ready to close out the estate and make distributions to the beneficiaries, make sure that all the cards are on the table, the accounting has been prepared and distributed, and that those beneficiaries are waiving any claims against you as trustee or administrator of the estate. Failing to do so can be a big mistake. Once you've distributed that money, you no longer have estate assets to defend yourself with, and if you get sued, now you're coming out of your own pocket to defend that lawsuit, hoping to get it back someday from that beneficiary. So really strongly encourage my clients to obtain releases from beneficiaries prior to final distribution, prior to any distribution, frankly, but especially prior to final distribution, so that person that's administering the trust is not wondering if they're going to potentially get sued and where they're going to get the money to defend. Those are the 5 mistakes that I see commonly made. I hope you found this video helpful. We'll talk to you later. Goodbye.